Welcome to another edition of Anglican Unscripted. This is episode 101, and you're watching two people fry in a hot studio talking to you about Anglican news. I'm Kevin Carlson.
And I'm George Conger. And today's July 7th, 2014.
George, before we move on to story one, let's bring the audience up to date about the changes we're making at Anglican Unscripted. We are actually going to be putting out 3 unscripteds per week. I don't have 3 hours. Where am I going to get 3 hours? I don't have 3 hours to watch. Don't freak out here. 3 episodes, probably be about 15 minutes each. So it's going to be the same duration, but more frequency, so we can be more update with the topics. And basically, George and I will do a story, and then we'll have another correspondent like Al and Peter or somebody else do a story. And it'll be a lot less work because we're going to tape it all in Monday and put it out slowly throughout the week, and then we can interrupt for breaking stories as they occur. George, we kind of have a breaking story here. We just got back from assembly, and there's a new archbishop. The Anglican Church in North America is alive and well, and women's ordination is still the #1 topic on any blog in the Anglican world. The new archbishop's name is Bishop Foley, and he's from Georgia. The growth in the church was what 16%?
Very good.
Oh, I got it. I memorized it. And women's ordination, to be determined, but stay tuned. We'll let you know more about that throughout the weeks. Now we're going to talk about church news today. And July 2nd, the Australian Church decided to change its canons to make sure that the rubrics that we understand the confession to be are not completely sealable. And when I say sealable, it means if I went into my priest and I said, I robbed the Bank of America and I want to confess my sin, he could not tell a police officer, or it cannot go any further than him. It was sealed in that room between me, the priest, and God. However, that is not exactly how the Anglicans and the Episcopalians interpret confession to be, George.
Well, 1982 canon on confession in Australia was just like you described. Mm-hmm. A priest can't share information he receives in the confession unless he's given permission to do so by the penitent. Now, on July 2nd, the Australian Church changed that rule. And if you confess to a crime, and the priest will say to you, unless you go to the police and confess, I will go for you and tell them you did this. And this was done in response to the terrible problem of child abuse, mm-hmm. because a number of Anglo-Catholic clergy in Australia used the seal of the confession as part of their abuse of children under their care, whom they sexually molested. Mm-hmm. It was a terrible, terrible situation. And the Synod unanimously voted to breach the seal of the confessional. And the new primate, Philip Freer of Sydney, Melbourne, got up, and he spoke to this issue and said that, you know, the seal of the confession was always considered to be this way. But we have to remember, folks, that the early Anglican reformers did not believe in the seal of the confession. And in fact, they were very harshly opposed to private auricular confession. In our prayer book, we have general confession, mm-hmm. where we make it with other people in the church on Sundays in Holy Communion. And the only exception was when a priest visited you and you were sick, and you had, if you will, a private confession because you couldn't get to church. But that was not license for anybody to come to the priest at any time and have a private one-on-one. So the Anglican Church in Australia said the problem of child abuse amongst this particular segment of our church who have abused what they understand to be a sacrament requires us to can it. And it passed unanimously.
It did.
Anglo-Catholics, liberals, evangelicals all voted for it. It wasn't that controversial there.
It was, but it became controversial when you put it in print.
It became controversial because, well, I don't know why. The Anglican history is quite clear on this point, that auricular confession was a no-no And it was one of the things the Oxford movement was attacked again and again and again by conservatives in the 19th century as saying, you're introducing Roman Catholic practices. Now, we sort of, as in all things Anglican, we go along to get along, and you do, if you want to have private confession, that's fine with you, fine with me, but don't make me do it.
Right.
And to be frank, private confession is a very, very rare thing in most Anglican and Episcopal churches. Some churches do it. I'm not saying that they don't, but it's not the norm. And it's because, at the end of the day, we have a different understanding of the nature of priesthood than the Catholics do, which is one of the reasons why you just can't, you have to be reordained if you become a Catholic priest, because we have a different understanding, different intention.
Via the magic of Skype, I have on the other line Alan Haley. He's from California. He's a surfer dude, and we're going to talk about legal news. A lot of you know that there's a trial coming up next week in South Carolina, and we're finishing a trial in San Joaquin. Let's do a quick San Joaquin update.
Sure. The trial judge now has rejected all of the objections we made to his proposed tentative decision. He changed it very little and simply adopted his tentative decision as the final decision. So now we're negotiating over the terms of the judgment.
And his tentative judgment said what?
His tentative decision says that all the property gets handed over to the Episcopal Church based on the Dennis Canon and other, misapplications of church law. So it's funny, it has to be noted. He says he bought the Episcopal Church's hook, line, and sinker, the line saying that bishops can't change the canons. They have no authority to change the canons of the Episcopal Church to take their dioceses out of the ecclesia. Well, and then this week we have Bishop Mathis down in San Diego publishing a circular to all his clergy saying, well, regardless of what the canons say, I'm going to authorize same-sex marriages from this point forth in the diocese.
Well, the San Joaquin ruling has what we call a catch-22. This basically goes back now to 1979, and every property that's sold needs to be reviewed and re-sold under general convention, correct?
Yeah, according to some other decisions out of California, that's right. Not this particular one, but the other one. Well, actually, by implication, this one too has the same deal, that only general convention can approve sales of property free of the Dennis Canon.
I've been paying attention.
Yes.
Just because I've been in an airplane for the last month doesn't mean I haven't been watching what's going on. Now let's move on to South Carolina. South Carolina is interesting because this is the most rapid court case we've had so far, despite the stalling tactics of the Episcopal Church. The Episcopal Church loves to take you to court, but they don't want to take you to trial.
They just avoid gunning to trial because I think it's the last stop on the stage before they lose, and then it goes up to an appellate court in these diocese cases. And it's interesting. They've tried every trick in the book to delay, and the last-minute delay was first they filed an appeal again from an interlocutory decision of Judge Goodstein. Interlocutory meaning it wasn't a final order; it was just a discovery order in the middle of the case, and you can't do that. But they did it anyway because in South Carolina an appeal stops the trial case. So they thought they would get the trial stopped that way. Judge Goodstein met and held a conference and said, I don't think this one stops it because it's nothing to do with what we're going to be trying the case about. And so she was prepared to go ahead. Well, they took an emergency appeal from that decision. She told, and the Court of Appeal this time, in a couple of hours, turned that appeal down and turned down the earlier appeal that they had filed too. And cleared the decks and said Judge Goodstein can proceed with her trial. So she held that because they had asked for a continuance on the ground they had not taken enough depositions yet, she said, you finish all of your depositions this Monday, July 7, and we'll start trial July 8. So they're going to be very busy on Monday. There's some 34 depositions they claim they need to take.
Well, they haven't called me yet, and don't bother.
The court reporters are going to be very, very busy in South Carolina. That's 34 court reporters.
Oh, my gosh.
Or 17 at least, because they've been tied up. I think they'll do 2 a day in each of the various parish churches across the diocese.
That's it. That's interesting. Now, it's not too late for them to come up with another Hail Mary. I mean, just because
it's getting down to the wire.
Yeah, it's getting down to the wire. But they've been known for the emergency appeals, and if you look at the history of the Episcopal Church, they have a high success rate with Hail Marys. Stuff that you would never think would ever. A judge would say, "Oh, this is complete poppycock. No way." Oh, stamp of approval.
We have to remind, there's 2 Hail Marys in the air still right now. Yeah. There's the one in the Fourth Circuit Federal Court, District Court of Appeal, the Fourth Circuit Court of Appeals, rather, in the federal system of courts. And that one is an appeal from the dismissal of Judge Hook in the Federal District Court. And so theoretically, he could get reversed and the case could get back up into federal court if the Fourth Circuit so holds. I doubt it will, but that's a Hail Mary. And the other one, of course, is in Fort Worth. They have filed a petition with the U.S. Supreme Court for review, and that, of course, would be very noticeable if the Supreme Court suddenly started paying attention to these cases. However, Supreme Court's in summer recess right now, and we won't find out until the first Monday in October whether that petition is going anywhere.
Well, we kind of know it won't. They had much better. They've had much better cases that they've said no to.
Exactly.
However, it's the Hail Mary policy it's interesting because of its success rate. Now, when do you imagine we're going to get results out of Carolina?
Well, I hope we can get some daily reports as things go on. Mm-hmm. It's going to be putting on a lot of testimony and documents, particularly with regard to the individual parishes that need to prove they own title to their own property, mm-hmm. free and clear of anything in the Episcopal Church. And hopefully that can be made a more systematic by a series of stipulations with regard to deeds and so on. But it's still going to take a while.
Well, each parish, because of Mark Lawrence, has a quit-claim deed.
Correct, but it doesn't end there. They're going to have to show the title going back and show that the Episcopal Church, they never dedicated their property to the Episcopal Church in some way and so on. So it's true, it has to be laid out, but they do each have to trace their history. And so there's everything's in their favor, and it should come out all right. The thing to watch, of course, is as the daily goes on, it will be the plaintiff parishes going first with their case, and the diocese making the case for the use of its trademark and its property and its history and all that. So this is one of those first cases in which the diocese gets to go as the plaintiff as opposed to the defendant. Mm-hmm. Quincy was also like that, and they prevailed with the judge in Quincy. So we'll see if they prevail with Judge Goodstein, and then in that case, of course, my guess is the trial will take up to 2 weeks. I think that's what's been set aside for it. And they're starting one day late, so it'll be crowded, but I'm sure she'll get them all to finish in time.
Sure. Well, you've dealt with many judges in your past. Is it a good policy to make the judge upset before you go to trial?
Yeah, that's certainly not. That's not.
All these
not a good way to do it.
All these Hail Marys are hard to watch because I could just see the judge going down again. Yeah,
well, some people take the attitude, well, we'll just get through this business at trial court. We'll win in the Court of Appeals. And, of course, in South Carolina, that's not the case because they've struck out there every time they've tried to get up to the Court of Appeals. They've lost there, too. And they lost their only case. They got up to the South Carolina Supreme Court. So on this one, they have to be figuring that they'll take it all the way up, lose it all the way up to the South Carolina Supreme Court, and then they'll finally get the U.S. Supreme Court to take a case. We'll see.
Let's talk.
We're talking 5 years down the line here.
All right. Well, let's talk quickly then about precedent in South Carolina. They've already decided church law regarding the Dennis canon in a previous case.
Right, and the standard line of the Rump Group is that, well, that was only as to one parish, All Saints Waccamaw, and it doesn't apply across the board. Well, that's misreading the decision because the court held squarely that the Dennis canon does not comply with trust law in South Carolina because people, in order to create a trust in South Carolina, the person who owns the property has to actually sign the deed of trust, putting the property into trust. And the Dennis canon doesn't even try to do that, so it held it was ineffective in South Carolina, and that was a statewide holding, so it would apply technically not only to Bishop Lawrence's diocese, it would also apply to Bishop Waldo's diocese of Upper South Carolina as well. Mm-hmm. And I think that Bishop Waldo's been treading rather gingerly in watching what's going on with Bishop Lawrence. and his parishes. He doesn't want to do anything that's going to make the Episcopal Church come down on him.
No.
But,
It's kind of been a Where's Waldo for the last 2 months. It's one of those things. All right, thank you, Alan, for your quick legal update.